Under Article 263 up to Article 266, the law punishes physical injuries. There are three kinds of physical injuries. We have serious physical injuries, less serious physical injuries, and we have slight physical injuries. Under Article 263, the following acts are punished as serious physical injuries. When the injured person becomes insane, imbecile, impotent, or blind as a consequence of the injuries inflicted on him. When the injured person loses an eye, a hand, a foot, an arm, a leg, or the use of this part of his body, or he becomes ill from the work in which is habitually engaged. Or when the injured person becomes deformed, or he loses any other part of his body, or the use of this part of his body, or he becomes ill or incapacitated from the work in which is habitually engaged for a period of more than 90 days. Or when the injured person becomes ill or incapacitated from the work in which is habitually engaged for a period of more than 30 days. All of these are punished as serious physical injuries. On the other hand, less serious physical injuries, we have less serious physical injuries when, by reason of the physical injuries inflicted by the accused on the victim would require medical intervention for a period of 10 to 30 days. Or when the said victim would not be able to perform labor for a period of 10 to 30 days. It is less serious physical injuries. There are three kinds of slight physical injuries under Article 266. First is physical injuries that would require medical attendance or would incapacitate the offended party from labor for a period of 1 to 9 days. Second is physical injuries that would not be requiring medical attendance or would not incapacitate the offended party from labor. And the third kind of slight physical injuries, ill treatment of another by deed. These are the three kinds of slight physical injuries under Article 266. In Article 263, serious physical injuries, when by reason thereof the victim becomes insane, imbecile, impotent, inability to copulate, or he becomes blind, both eyes could not see, that is serious. If only an eye could not see, then it is still considered a serious physical injuries, but in the second category. If by reason of the physical injuries inflicted by the accused on the victim becomes deformed. So the said victim becomes deformed, the said injury caused a scar, a deformity on any part of the body which is conspicuous and visible, resulting to the physical disfigurement of the physical appearance of the said person, then it is considered as deformity. The moment an injury would cause deformity on the victim, you do not consider the healing period. Even if the medical certificate states it would heal within a period of 15 days, and therefore it would amount to less serious physical injuries, the fact that it has a scar, and that scar is located in a conspicuous part of the body, it resulted in deformity, you do not consider the healing period, it will be considered as serious physical injuries. In case of, if the physical injuries inflicted would make the offended party ill or incapacitated from labor for a period of more than 30 days, it is already serious. If it is 10 to 30 days, it is less serious physical injuries. If it is 1 to 9 days, it is slight physical injuries. A third kind of slight physical injuries is ill treatment of another by deed. Ill treatment of another by deed is when the said offender inflicted by this act physical pain on the part of the victim, but no injury or no wound was produced. It is ill treatment of another by deed. The victim was walking, the accused was following the victim, and when the accused saw an opportunity, he hit the back of the head of the victim strongly with a lead pipe. Thereafter, the said victim was suffering from so much pain. He fell on the ground. The accused immediately left. The victim was brought to the doctor. Based on the medical certificate, the head, despite the pain, did not sustain any wound, did not sustain any injury, no injury at all by the act of the accused of hitting the victim. The accused was charged of attempted murder. Is the accused liable as charged? Supreme Court said the accused is not liable of attempted murder. The accused is liable of slight physical injuries, in particular, ill treatment of another body. The act of the accused of hitting the back of the head of the victim with a lead pipe brought pain on the head of the victim, but there was no injury, no wound inflicted on the victim. Therefore, it is an act of ill treatment of another body under Article 266. The wife was so mad at the concubine of her husband. And the concubine was so beautiful. And she wanted the concubine to lose that beauty. And so, she tried to know the places where the concubine usually go. And she knew that the concubine every Friday morning would go to this beauty clinic. And so one time, she waited for the said concubine to get out of the said beauty clinic. Upon getting out, the said wife was hiding behind a car. Upon getting out, the moment the said concubine got out of the clinic, before the concubine was able to board her car, here comes the wife, and the wife sprayed a toxic substance on the right face of the said concubine. The right face of the concubine was burned. She was brought to the doctor, to the hospital, and the doctor's medical certificate state that the burn on the right face would heal within a period of 30 days, for a month. However, there will be a scar left on the said right face. The entire right face now will be deformed. There is a scar. What crimes should be filed against the said wife? The wife should be charged with qualified serious physical injuries. The act of the wife of spraying toxic substance on the right face caused deformity. It was located on a conspicuous part, the right face. It caused ugliness on the part of this beautiful concubine. Therefore, it is a deformity. So even if it would naturally heal for a period of 30 days, therefore amounting to less serious physical injuries, but since the scar would remain for life, then it is serious physical injuries. And since the act of spraying toxic substance was done with treachery, one of the qualifying circumstances in the crime of murder, therefore it is qualified serious physical injuries. In case of serious physical injuries, the following circumstances will qualify the imposable penalty. First, when the serious physical injuries is inflicted upon any of the persons stated or enumerated in parricide. So if the serious physical injuries is inflicted on the father, mother, child, whether legitimate or illegitimate, legitimate other ascendant, legitimate other descendant, or the legitimate spouse. If the serious physical injuries is inflicted on this person, it is qualified. Another qualifying circumstance is if the act of inflicting serious physical injuries is attended by any of the qualifying circumstances for murder. That is applicable in the problem. The spraying of the toxic substance resulting to deformity was attended by treachery. Obviously, the wife adopted the means she will use so that the said concubine would not be without any defense. Hence, it is qualified serious physical injuries. What if the husband and the husband and the wife were fighting While the husband and the wife were fighting, arguing on a personal matter, particular money matters, here comes their only son. Their only son tried to intervene. But the father interpreted it that the son was siding with the mother. And so the father got mad with the said son. And as a result thereof, both the father and the son had this fight. And the son was bigger than that of the father, and the son lost control already of himself. And so he backs and backs, kicked, punched and punched his father, until his father was wounded and injured, lying on the floor. Thereafter, the father was brought to the hospital. He himself brought the father to the hospital. And the medical certificate revealed that the injury sustained by the father would heal within a period of 20 days. What prior crimes had been committed by the son? If the injury sustained would heal within a period of 10 to 30 days, it is less serious physical injuries. Here, it is 20 days, therefore it is less serious physical injuries. But since it is committed by the son on his parent, on his ascendant, therefore, the crime committed is qualified less serious physical injuries. The following circumstances would qualify less serious physical injuries: if there is a manifest intent to offend or insult the injured person, when any act amounting to ignominy attended the act of inflicting injury, when the said offender inflicted injuries on his parent, ascendant, guardian, curators, or teacher, or when the victim is a person in rank or a person in authority, provided it will not amount to direct assault. Any of these will qualify the crime of less serious physical injuries. The victim filed a case of physical injuries against X, filed a case of slight. X filed a case of less serious physical injuries against Y before the office of the public prosecutor. So, based on the sworn statement, the affidavit of the said victim, this accused inflicted upon him physical injuries. And there were pictures of the wound, the abrasions, the hematoma that were inflicted by the said accused. However, there was no attached medical certificate. And so, during the clarificatory hearing, the investigating public prosecutor told the said complainant, "You give me the medical certificate. You went to the doctor, right?" And he said, "Yes." "Then give me, attach a supplemental document, your medical certificate." The fiscal waited for a week, but no medical certificate was produced. The said complainant didn't anymore come back. There was evidence that physical injuries were inflicted, but there was no medical certificate showing the required medical intervention. If you were the public prosecutor, what crime would you file against the said respondent? If you were the public prosecutor, you have to file only a case of slight physical injuries. Even if there was this evidence, based on sworn statements saying that he was inflicted with these injuries, causing hematoma, contusions, abrasions, etc., but absent that medical certificate stating for how long he would be healed, then you have to file only slight physical injuries.